Imagine this. Your boss makes an inappropriate comment, a coworker keeps asking you out after you've said no, or someone in the office jokes in a way that makes you feel uncomfortable. You might wonder, is this just rude, or does it count as sexual harassment under the law? Here's the truth. Under U.S. law, sexual harassment is a form of sex discrimination, and it's illegal in the workplace. But not every awkward moment crosses the legal line. To count as harassment, the conduct must be unwelcome, based on sex, and severe or pervasive enough to create a hostile work environment, or tied directly to job benefits. In this video, we'll break down exactly what counts as sexual harassment, the two main types recognized under the law, real-world examples, and what you can do if it happens to you. Part 1. The legal definition of sexual harassment. Sexual harassment is defined under Title VII of the Civil Rights Act of 1964 as a form of sex discrimination. The Equal Employment Opportunity Commission, EEOC, which enforces Title VII, explains that harassment becomes unlawful when 1. The conduct is unwelcome, 2. It's based on the employee's sex, gender, or sexual orientation, and 3. It's either severe or pervasive enough to create a hostile or abusive work environment, or it involves a supervisor linking job benefits to sexual conduct, what the law calls quid pro quo harassment. Importantly, harassment doesn't have to be sexual in nature. For example, constant negative remarks about women in leadership or mocking someone for their sexual orientation also count. Examples of behaviors that may qualify as sexual harassment include unwanted touching, hugging, or physical advances. Repeated requests for dates after being rejected, sexual jokes, slurs, or comments that create a hostile environment, displaying offensive images, posters, or screensavers, promising a promotion in exchange for sexual favors, or threatening termination if the employee refuses. The law looks at the totality of circumstances. A single offhand remark may not meet the threshold, but repeated behavior, or even a single serious incident, like assault, can qualify as harassment. It's also important to know that harassment can come from anyone in the workplace: a supervisor, coworker, client, or even a contractor. Employers are responsible for addressing harassment once they know about it. The standard isn't just what the victim felt. Courts ask whether a reasonable person would also find the behavior hostile or abusive. This ensures that claims are judged fairly without minimizing genuine harm. So, under the law, sexual harassment is about more than just offensive behavior. It's about unwelcome conduct based on sex that undermines a person's ability to do their job. Part 2. Quid pro quo. Harassment, when job benefits are tied to sexual conduct. One of the clearest and most serious forms of sexual harassment is called quid pro quo harassment. The Latin phrase means this for that, and in the workplace context it happens when job benefits are explicitly or implicitly tied to sexual conduct. Here's how it works. A supervisor or manager conditions employment decisions, like hiring, promotions, raises, or even keeping your job, on whether you agree to sexual advances. For example, if a boss says, "Go out with me or you'll lose your shift," that's quid pro quo harassment. Likewise, if a manager hints that agreeing to a sexual relationship could lead to a better position, that's illegal. Quid pro quo harassment usually involves someone with power over the victim's job, because supervisors can influence hiring, firing, or promotions. The law treats their conduct as the employer's responsibility. Even a single incident of quid pro quo harassment is enough to violate Title VII. You don't need to show a pattern or ongoing behavior. The EEOC has made it clear. This form of harassment doesn't require physical contact. Verbal threats, implied promises, or even repeated pressure from a superior can count. The key question is whether job benefits or detriments were conditioned on sexual compliance. Real-world examples include a manager telling an employee she'll only get a raise if she spends time with him after work, a supervisor threatening to fire someone if they don't agree to a sexual relationship, a recruiter offering a job in exchange for sexual favors. It's also important to know that employers can be automatically liable for quid pro quo harassment by supervisors. Unlike other harassment claims where workers must prove the company failed to address the issue, quid pro quo doesn't give employers much room to escape responsibility. This type of harassment is especially damaging because it attacks the core of workplace fairness. Employees should succeed based on merit, not because they gave in to coercion. That's why courts and agencies treat quid pro quo cases very seriously. So, if job benefits are ever linked to sexual conduct, even subtly, that's not just inappropriate, it's a direct violation of federal law. Part 3. Hostile work environment. When harassment creates an abusive workplace. Not all sexual harassment comes in the form of quid pro quo threats. In fact, the most common type is what the law calls a hostile work environment. This happens when unwelcome conduct based on sex is so severe or pervasive that it creates a workplace that a reasonable person would find intimidating, hostile, or abusive. Unlike quid pro quo, hostile work environment harassment doesn't always involve direct job consequences like firing or demotion. Instead, it poisons the day-to-day atmosphere, making it harder, or even impossible, for the victim to do their job comfortably. Examples include repeated sexual jokes or comments that make employees uncomfortable, persistent unwanted flirting or requests for dates after being told no, displaying pornographic or sexually suggestive images in the workplace, rumors or offensive remarks about someone's sexuality or gender identity, physical actions like unwanted touching, brushing, or blocking someone's path. One important factor is frequency and severity. A single inappropriate joke may not rise to the level of harassment, but a pattern of offensive behavior certainly can. On the other hand, a single severe incident, such as sexual assault, may be enough by itself. Courts look at the totality of the circumstances, including the nature of the conduct, how often it occurred, whether it was physically threatening or humiliating, and whether it interfered with the employee's ability to work. The victim's own reaction matters, but so does how a reasonable person would view the behavior. It's also worth noting that harassment doesn't have to come from a boss. Coworkers, clients, or even customers can create a hostile work environment. Employers are responsible for addressing the problem once they know, or should have known, about it. If they ignore complaints, they can be held liable under Title VII. Hostile work environment claims often involve gray areas because behavior that one person sees as just joking can be deeply offensive to another. That's why the law uses both subjective, did the victim feel harassed, and objective, would a reasonable person feel harassed, standards. The bottom line, a hostile work environment is more than just a bad vibe. It's a legally recognized form of sexual harassment that employers have a duty to prevent and correct. Part 4. Employer responsibility and retaliation protections. When it comes to sexual harassment, the law doesn't just hold individual harassers accountable, it also places serious responsibilities on employers. Under Title VII of the Civil Rights Act, companies are required to take reasonable steps to prevent and promptly correct harassment in the workplace. For quid pro quo harassment, employers are usually held strictly liable if it was committed by a supervisor with authority over the victim. That means the company can't escape responsibility by saying, "We didn't know." If a boss ties job benefits to sexual favors, the employer is automatically on the hook. For hostile work environment cases, liability depends on how the employer responds. If the harassment comes from a coworker, customer, or lower-level supervisor, the company can still be liable if it knew, or reasonably should have known, about the behavior and failed to act. That's why reporting harassment is so important. Employers are expected to investigate complaints, discipline offenders, and prevent further incidents. The law also protects workers who speak up. Retaliation, punishing someone for reporting harassment or participating in an investigation, is itself illegal. Retaliation can take many forms: firing, demotion, pay cuts, schedule changes, exclusion from projects, or creating an even more hostile environment. According to the EECC, retaliation is the most common type of charge filed in workplace discrimination cases. To defend themselves, many employers point to their anti-harassment policies and complaint procedures. Courts often ask whether the company had a clear policy, whether it trained managers and staff, and whether it responded appropriately to complaints. If an employer can prove they provided reasonable avenues for employees to report harassment, but the victim never used them, that may reduce liability. Still, employers can't just write a policy and ignore it. They must actively enforce it. That includes training supervisors, handling complaints confidentially, and protecting employees from backlash. For workers, this means two things. 1. Report harassment through official channels if possible. It strengthens your legal protections. 2. Know that if your employer retaliates, that retaliation can be just as illegal as the harassment itself. The message of the law is clear. Employers must take harassment seriously, stop it when it happens, and never punish workers for standing up for themselves. Part 5. What workers can do if they experience sexual harassment. If you're experiencing sexual harassment at work, it can feel isolating and overwhelming. But remember, you have rights and options. Here are the key steps workers can take. 1. Document everything. Keep detailed notes of each incident: dates, times, locations, what was said or done, and who witnessed it. Save emails, texts, or other written evidence. A strong paper trail can be critical if your case goes to HR, the EEOC, or court. 2. Use internal reporting channels. Most employers are required to have anti-harassment policies. Report the harassment to HR, a supervisor, or another designated person. Submitting a complaint in writing creates a record that the employer knew about the problem. Even if nothing changes, making the report protects your rights if you later pursue legal action. 3. Protect yourself from retaliation. If your boss cuts your hours, demotes you, or treats you worse after you file a complaint, that's retaliation. And it's illegal under Title VII. Keep records of any negative changes after your report, since retaliation itself can be grounds for a claim. 4. File a charge with the EEOC. If the harassment continues or your employer fails to act, you can file a complaint with the Equal Employment Opportunity Commission, EEOC. The deadline is usually 180 days from the last incident, extended to 300 in some states. The EEOC will investigate, may offer mediation, and can issue a right to sue letter, allowing you to bring your case to federal court. 5. Consider legal advice. An employment lawyer can help you understand the strength of your case, navigate EECC procedures, and file a lawsuit if necessary. Many lawyers work on contingency, meaning they only get paid if you win. 6. Know the possible remedies. If harassment is proven, workers can recover back pay, reinstatement, compensatory damages for emotional harm, and even punitive damages if the employer acted especially badly. Courts can also order employers to improve policies and training to prevent future harassment. Real-world cases prove these protections work. For instance, a group of hotel employees who endured repeated harassment from a supervisor won a settlement that included back pay, damages, and mandatory anti-harassment training for the company. These cases send a clear message. Workers don't have to accept harassment in silence. The bottom line, While reporting harassment can feel risky, the law is on your side. By documenting, reporting, and using the legal process, you can protect yourself and help build safer workplaces for everyone. So, what counts as sexual harassment at work? Under U.S. law, it's any unwelcome conduct based on sex that either creates a hostile work environment or ties job benefits to sexual favors, what the law calls quid pro quo. It can come from supervisors, coworkers, or even customers, and it's always the employer's responsibility to stop it once they know. The law also protects workers from retaliation when they speak up. That means you cannot be legally fired, demoted, or punished for reporting harassment or joining an investigation. If you experience harassment, remember, document what's happening, report it, and if necessary, file a charge with the EECC. Many workers have won justice, back pay, and stronger workplace protections by standing up. If this video gave you clarity, hit like, share it with someone who might need it, and subscribe for more plain English guides to workplace law. And in the comments, let me know. Do people where you work understand what really counts as harassment?